coming. I request for the guests. All the students, please rise for the guests. Should we start? I'll ask them to be seated. All of you, please be seated. Respected Chief Guest, Honorable Mr. Justice Navas, Sir, Judge, Supreme Court of Sri Lanka, Guest of Honor, Professor Dr. R. Venkata, Sir, Vice Chancellor, India International University of Legal Education and Research, Goa, Guest of Honor, Professor Dr. Jigimon V.S. Sir, Director, Amity Law School, Amity University, Mumbai, Professor Dr. Dinkar Gitte Sir, Principal, KLE College of Law, NAVI, Mumbai, dear faculty members, students, and all the attendees. It is my great pleasure to extend a warm welcome to each one of you to this international symposium on justice delivery system in Saarc countries, organized by KLE College of Law, NAVI, Mumbai. We are honored to have with us eminent legal experts who will enlighten us on the complexities, challenges, and innovations in the justice systems of Saarc nations. The South Asian region, with its rich legal traditions and diverse judicial structures, plays a crucial role in ensuring justice, upholding human rights, and strengthening the rule of law. Today's symposium is an opportunity for us to gain deep insights from renowned legal minds who bring invaluable experience and expertise. I extend my sincere gratitude to our distinguished guest speakers for taking the time to share their wisdom with us. I also appreciate the efforts of the faculties and students who have worked diligently to make this event possible. Before we proceed further, it is our privilege to felicitate our distinguished guests as a token of our deep appreciation and respect for their contributions to the legal fraternity. Firstly, I request Principal Sir to felicitate our chief guest for today, Honorable Mr. Justice Navas Sir, Judge Supreme Court of Sri Lanka. Thank you, sir. I further request Principal Sir to felicitate our guests of honor, Professor Dr. R. Venkata, Sir, Vice Chancellor, India International University of Legal Education and Research, Goa. Thank you, sir. I again request Principal Sir to felicitate our next guest of honor, Professor Dr. Jigimon V.S. Sir, Director, Amity Law School, Amity University, Mumbai. I now request Assistant Professor Pooja Bijargi to felicitate our Principal Sir. Once again, a warm welcome to all. Let us now begin what promises to be an enriching and thought-provoking session. I now call upon Assistant Professor Ashwini Muthulakshmi to formally introduce our distinguished guest of honor for today, Professor Dr. Jigimon V.S. Sir, to our audience.
Thank you, ma'am. I have the distinct honor of introducing Professor Dr. Jigimon, Professor of Law and Director of Amity Law School, Mumbai. Professor Dr. Jigimon, sir, is a guide and mentor to many of us here, including me, and currently serves as the Director of Amity Law School at Amity University, Mumbai. With a rich and diverse academic and professional background, Dr. Jigimon sir's career is marked by his dedication to legal education and significant contributions in the field of IPR. Before joining Amity Mumbai, Dr. Jigimon was the DP IIT IPR Chair at Maharashtra National University, Mumbai, appointed by the Government of India. In this role, he served as the Director of the Center for Research in Intellectual Property. Sir has over 2 decades of experience in teaching, research, and practice, and this has seen him hold several key positions, including being the founder head of the department at Dharmashastra National Law University, Jabalpur, Mark Gregorius College of Law, and Sir has additionally also served as the Registrar of the Bar Council of Kerala, M.K. Nambiar Academy for Continuing Legal Education in Kochi. Sir was the Chair Coordinator of the Padma Bhushan Professor N.R. Madhava Menon Chair on Legal Education and an expert member of the Legal Education Committee of the University Grants Committee on Transforming Legal Education. From 2012 to 2017, he closely worked with Padma Bhushan Professor N.R. Madhava Menon sir, organizing professional development training programs for lawyers and law teachers across India under continuing legal education. His standing in the legal community is further reflected by his membership in several prestigious organizations, such as the Forum of South Asian Clinical Law Teachers in Goa, the Global Alliance for Justice Education in the USA, and his role as the executive member of Commonwealth Legal Education Association Asia India and Secretary of the Menon Institute of Legal Advocacy Training, Trivandrum. I take great pleasure in inviting Sir to address this gathering.
Good afternoon, all of you. Good afternoon. I just wanted to make sure nobody's sleeping. It's an honor and pleasure that my friend has invited me for such a colloquium in which legal personalities like Honorable Justice Honorable Justice Navas, who's been the judge of the Supreme Court of Sri Lanka, is there, and former teacher, guide, whatever nomenclature you can add for a student. I can call up Professor Venkata, who has some meeting there. He's there, and my close friend, Professor Dinakar Gittesa, is also there. And when he told me that I had to speak about a topic which you need a lot of deliberations to understand the complete justice delivery system in this our country, I was thinking what I should start off, because scholars are there who could speak more better about this our country level. So I thought like I should put upon a point to speak more on the role of the legal education in providing or in developing the justice delivery system in and the role that the legal education institution plays for providing such kind of, the assisting the justice delivery system, the role that India plays in assisting the justice delivery system is concerned. So something which came to my thought in 4 or 5 points that I wanted to mention was, first thing is, where do we start the complete justice delivery system in the country is concerned? We focus majorly as an education institution, we start with the colleges that are being run by the various institutions, various management, various bodies, various institutions, government, aided, unaided, so many categories are there. And these are being controlled by an organization called as the Bar Council of India and the award granting or the recognizing organization called as the University Grants Commission. So these two are the organization which gives us the power or empowers the education institutions like us to start with the first step of providing the education to these people who later on become either the providers of the justice delivery system or as part of the justice delivery or assisters of the, I call it as advocates, the judges, the role other than the judges, there are so many roles that we play that we can all associate that with the justice delivery system. And this is almost similar in almost all the SAARC countries that we have. It is almost fascinating to understand that certain SAARC countries like Bhutan and Sri Lanka, I take it as an example to mention that there the control of the law colleges also is under, or is been having, what do you call that, is also has a role where the judiciary also has a power or to implement or to control the legal education system over there, which unfortunately in India we do not have, because they totally has been under the control of organs. Yes, when some of you go to court for some access to some of the requirements at the law colleges are concerned, the judiciary interferes. And the latest one is Justice Suryakant sir's judgment on the Bar Council has no role to interfere into the legal education, let the academicians manage it. So that is where the things comes in. So coming back to your topic, the legal education. So it starts from the law colleges where you go into, and you know that the requirement of lawyers in the justice delivery system that we have in India is far, far higher than what we produce in these law colleges. Okay, we have how many crores of cases pending? Anybody can guess? 3 crore, 4 crore? Yeah, we have quite high number. It's close to 3 crore of cases pending in various courts in India. I'm not mentioning just about Supreme Court. You look at the justice system that we have, we start from the lower courts. So the lower courts are the actual battlefield where the public depend upon, right? And if I take up on a point to say that the Supreme Court is only accessible for those who are in the elite area, right? Because for them, with a judge Supreme Court sitting over here, I shouldn't say that. For them, for us to reach up to Supreme Court, we have to travel from this place to, for a common man, is it possible? Right? That's the only point that I was mentioning. So for us, the lower, the strata that we have at the district level or the taluka level is where the access totally depends upon. And from there, to reach over to there, colleges like ours play a major role in it. Why I said colleges like ours? It is not the national law universities that we have in the legal education system tier, which is at the top, which provides lawyers for the lower courts. Even Dinakar sir agreed to this, because we might have seen many our students in the lower courts than the National Law School, right? So National Law School is the top tier institution in the legal education structure of India is concerned. And we have 24, 25 now, because if Jammu and Kashmir comes in, 26 national law universities coming into play where the legal educators are, the lawyers have been produced into. And very few of those institutional lawyers go into lower court. So this is where your role also comes in, my role also comes in my instance, the educators, the legal education runners' roles comes in the Saarc level for providing best lawyers to access justice to the people who are very at a lower level. We call mostly that is a pro bono work that normally we do. If you go to, when you pass and become a lawyer, first few years of your advocacy will totally depend upon the pro bono work that you get from the court. I was a lawyer, so I also got a case as a pro bono case when you attach yourself to the legal aid committee of the taluka level or the district level. So that is the work where actual justice delivery system starts from your point of view or from my point of view, where the education institution trains you to go in further for that. So this is the first point of level where the education institution plays a major role in there. And in this education institution, what we teach is what has been prescribed by the concerned universities or the institutions that have their control over the complete education structure is concerned. Okay, let me put a question to you. How many subjects do you learn in your entire LLB period? Right? You come and give exams, but you don't remember the number of subjects, right? This always happens with it. No, don't worry. This is the same thing. I was also a student like you. I also had the same dream of how many subjects you have learned. 40, 50, 30. To be very precise, you learn 20 compulsory papers, right? 20 compulsory for 5, I'm saying about 3 year course. 20 compulsory papers, 6 optional papers, right? And any additional papers that the college teaches? Yes or no? Some small programs, some seminars, something like that. Those are all add-on trainings that the college gives. Why? The syllabus, what you learn, is not what is practiced in the court of law. But what extra the colleges gives you more equipment to be a better person in the court of law. And that is where I say, we try to reach out to that particular, make you to reach out to that particular point of place from where you can take up something. No, we give you degrees. We give you LLB degrees or BSc LLB degrees or whatever the nomenclatures are there. 5-year, 3-year, bas dono hi hai, aage nahi hai. So 5 and 3-year courses, right? But how can you go in before a court of law, before a judge, and then argue? How do you learn that? We can't. It's not possible for you to learn everything in the classroom. That is where your internship programs, your moot courts, your ADR clinical papers are there. So you missed out these 4 papers. These are also part of your syllabus. So 20 plus 6 plus 4 clinical papers. Kitne hue? Bas? In the 30 subjects that you learn, you're trying to learn the entire law of the country. Is it possible? That's what I was coming to do. We are limiting ourselves to the limited space that we get into. But the cases that comes into you are very different. I still remember when I saw the name of Felicitation Nirman's the book, he has made a statement once. He always carries a constitution, a CRPC, or whenever he goes to court, he carries a Bear Act. And he said that, this was in discussion with Felicitation Nirman sir and Madhav Menon sir, who was my teacher, who is known to sir also as a very renowned person who has restructured the entire legal education structure into, we call him the Bhishma Pitama of the legal education of the country. So he was having a talk with Felicitation Nirman sir, and he asked you, do you know this particular act and do you know this particular section? He said in very witty manner, sir, if you pay me, I'll read it and I'll tell you. If you pay me, I will read it and tell you. Why? Until unless somebody pays a lawyer, nobody opens that particular act. That is where the entire legal education structure is all about. So you have so much of legislation, so much of cases, so much of things is there. But how do we learn all those things? This is the one area which is more looked upon into when it comes to the justice delivery system in the country is concerned. The second point I wanted to mention is what? Are we producing the required number of lawyers that is needed? Is it again a statement that the former Prime Minister Manmohan Singh said, that we have a large sea of lawyers with few islands of excellence, right? An example is Felicitation Nirman sir. Who is he? He's a very renowned personality, right? But he has so many number of cases. Go to a taluka court, you may find lawyers running. We call it as ambulance chases. Chases you have seen, some of you might have seen this, a video of, the movie of ambulance chases. There are also people like them. So but too many cases are there for us. But we haven't equipped ourselves for the purpose of getting or to providing justice to these people. That is where I said there are other countries which limit the entry of lawyers on the basis of number of cases coming into court. That has been controlled in many of the Saarc nations, which probably in the future to come, because we are slowly coming out with a all India bar examination, the so-called bar examination, where you can all pass. But to limit later on, probably in the future years to come, they may say the only 100 seats, those who pass, 100 people who pass will be only able to enroll. So that regulation has to come in for the purpose of regulating or providing proper justice to people when it comes to access to justice is concerned. Now, this is the second area which is a concern for all of us with regard to the legal profession is concerned. Now, the third area is which strikes my mind while I was going through one of the articles was, you know how many district courts we have in India? Anybody? According to the data of the judiciary, it says roughly around 32,000 courts are there in the country. I know how many judges in these courts. I mean, I meant district courts in the sense to all the district judiciary, the lower courts to the district judiciary. You know how many judges are there in this country, the lower judiciary? We only have roughly to 17 to 18,000 of them. So that means the 50% of the courts are. That is also one of the requirements that we need to look into, because we need more judges in these courts so that the courts in this level are able to be accessed by the people. That is one of a big reason why there is a lot of pendency of cases in the courts. This is another hindrance to the justice delivery system in the country. And the next important area this we also look into is the jails that we have. I mean, probably you might have visited your, the local jails over here. How many of you have gone to see the jail, not in the jail? Have you gone to see the jails? See the jails? Very few. How many of you gone to see the police station? How many of we, because of police called you, went to police station? Because in most of the 3-year course, if I may be corrected, that most of the 3-year course, people who join for the course have some conflict with law. Conflict with law, I said, because they have a case in which they have to going to court, and because of which they thought, okay, anyway, this case is going to take 5 years. I will finish my law in 3 years, and I can save my 2 years fees. And we go to the courts, right? That's how we normally look into the, that's how we get so many students coming who are doctors, who are engineers, who are from various other background to joining the law courses are concerned. Getting it. So this, the point I was mentioning was the jails. This is a part of the justice system that we have. We call it as the total criminal justice system is based on these, the prisons that we have. And the crowding of prisons is increasing every year. We are short of prisons in India. And thanks to the legal aid committees, thanks to the legal aid work that the lower judiciary, district judiciary, higher judiciary are doing, that we are able to understand how many percentage of people who are under trial prisoners who have almost completed their term of jail for which the crime they have done. Because nowadays the jail has very good food, lot of facilities available. You can read, write, cook, eat, whatever you want. So many things are available. Because number are more, work is less. So many people get rest on certain days. Food is also good. I was told by students who visited, one of my faculty member did a research in about the women prisoners in the state of Maharashtra, and she was telling me that they got best food than the hostel foods that we have. So that is one of the reasons people don't want to go out of the jail also. I do not know, but this is also a reason why this is also part of the justice system that we have in the country, where there is a need for us to understand how to control or how to eliminate or how to send out the people who have completed the term of jail in which for which they have been caught in any cases are concerned. So this is the third part of the justice system that we have in our country is concerned. Now, a few minutes back, there was also a talk we had with regard to the number of how to address the issues of lack of courts in the country is concerned, because every person who is from southern tip of India, that is where I belong to Kerala, then after the Kanyakumari comes in. So Kanyakumari to Kashmir has to go to one court for the purpose of addressing their issue, right? Maybe if we make it more accessible, people might go more often to the court. That may be also a reason why the Supreme Court doesn't want to have sittings in other states are concerned. So it could be, that is also one of the reason I found out to be a problem with regard to the court systems are concerned. Now, if you look into the use of technology, like last 2 days we were having a very high discussion on law, technology, integration, how court systems could change, how the evidencing could change in the justice delivery system is concerned. So there is very limited number of courts who still have or uses technology for the purpose of managing the system is concerned. There have been many cases in which the files of the courts gets missing. While practicing, we know the technique of how the file can be kept pending. You will learn that. You will learn those techniques when you go to courts. But don't learn that, because that is one of the reasons why people, even if there is out of the total population, if the belief of court, that see you in court, the statement that we always make, is still there because they still believe in the judicial system. So there is no management of cases that is concerned within the court system is happening. So that can only be integrated with technology, can be used for those kind of purposes. There was a system of court managers which was introduced in the few years back. It has to be stopped because the managers who came, they were all management students. They didn't understand anything regarding court. They were failure because of that. So thereafter, they thought about having students who have LLB degree to go for become an MBA graduate, then they can be taken. But in the long run, the system made to fail it. So there is a requirement of use of technology for the purpose of practice, wherein you could reach out to courts using the technology. COVID taught us, right? COVID taught many things to us also, how to use more mobile phones. But the best part of it, that court was started to be getting accessed by people in the lower areas, in the village areas also. So that, again, is not happening right now because most of us are very reluctant to adopt technology into the legal practice system. So if we can utilize that, that can also always develop the system in the country is concerned. But obviously, we have the best of the judiciary in the world over, because there are so many countries which refer to our judicial system for any such conflict or any such use of law is concerned. And we stands out to be a protector for many countries. I mean, if I still remember right, it was a South African judge who, in a meeting which happened in Kerala for the Commonwealth Judicial Education Institution, there's an institution for the judges to train on the Commonwealth country. In the meeting in Kerala, I was also part of the organizers. So one of the South African judge stood up in a meeting and he said that because of the Novartis judgment, they could utilize the ratio in the judgment to make accessible the medicines to the public over there without an interfering from the industries are concerned. So that much influence that our judiciary has over many countries are concerned. So it's a very strong judiciary, but yeah, there is a lot many things to be done, or lot many things to be upgraded upon, or needed to be influenced upon on these complete justice system is concerned. So I don't want to bore you with my lecture, because I mean, when your teacher gets a mic, you know that it goes on and on. But just want to last conclude with saying that if I may be corrected if I am wrong, I would say that proper justice begins in a law college classroom. Proper justice begins in a law college classroom, because if you are not properly trained to provide the needy, the needy, I'm saying the word specifically the needy. We may provide justice to so many people. There are a lot money comes in when you provide justice to so many people. There can be so many, so many gundas who come to you for a bail. You may get a lot of money because he wants to be out. But actual justice is provided to people, and that justice to the needy can be only provided if it is being properly taught in the classrooms within the law college. So there is a very important role that as teachers that we have, or the important role as a legal education institution we have in making or in strengthening the justice system in the world over is concerned. So that happens here in this classrooms in this area. And students, you have a major role to be a part of this justice system, whichever state or whichever taluka that you belong to. One last thing that I will mention before I conclude. A student who comes from a taluka where he or she is from to a city college for the purpose of education tries to remain within that city area. Why? Because of fascination that the city carries. But I would say that same student should go back to his village, because that is where the people know you and understand that you are more accessible and more valuable in that state, in that district or taluka is concerned. And that is where you will be able to provide and you will be able to understand what is the requirement according to that particular area is concerned. So you have more role of providing or strengthening the justice system in the country when you go back from where you belong to. And that is where the complete, I would say the completion of a job of a law teacher is concerned, to make sure that you are accessible for needy and provide justice to people over there. That's all. Thank you for listening to me. I know after lunch it's very boring to listen to lectures. I see many of you are still trying to keep your eyes open, and I was trying to make sure that your eyes are still open before the other speaker comes in. So with that, let me thank all of you for listening to me, and I thank also my friend Professor Dinakar, the principal of the college, Madam and my student, where is she? Ashwini, she is my PhD scholar in Amity University, and there are other students also there who are also PhD scholars over there. And thank you for inviting me, and it was a pleasure speaking to you and wishing you all the very best. Jai Hind.
Thank you, sir, for your profound insights and for delivering such a thought-provoking address. Your words have truly enriched our understanding today. I now request Assistant Professor Pooja Bijargi to formally introduce our respected chief guest for today, Honorable Mr. Justice Navas, sir, Judge, Supreme Court of Sri Lanka.
It is my privilege to introduce our chief guest for today's event, Honorable Mr. Justice Dilip Navas, sir. Sir is a highly respected Sri Lankan lawyer who currently serves as a puisne justice of the Supreme Court of Sri Lanka. Appointed to this esteemed position, Justice Navas has been serving with distinction since 2020, making significant contribution to the judicial landscape of Sri Lanka. Before Sir's appointment to the Supreme Court, Justice Navas held the prestigious role of acting president of the Court of Appeal of Sri Lanka. His leadership and judicial expertise were further recognized when he was formally appointed as the President of the Court of Appeal on 3rd February 2020, while continuing with his duties as a judge to the court. Honorable Mr. Justice Navas secured the prestigious award offered by United Kingdom known as British Chevening Scholarship and obtained his first LLM in commercial and corporate law. Thereafter, in the year 2018, the government of United States awarded him a Fulbright scholarship, through which Sir obtained his second master's in the transnational commercial and criminal law. Sir also holds a third LLM in constitutional and administrative law from University of Colombo. With such a strong academic background, Sir has demonstrated an unwavering commitment to upholding the principles of rule of law, fairness, and justice throughout his career. His tenure as President of the Court of Appeal, in conjunction with his current role as a puisne justice of the Supreme Court, highlights his significant contribution to the Sri Lanka's legal system. Renowned for his legal acumen, leadership, and dedication to justice, Sir commands respect both within the judiciary and across the broader legal community. Now I would request Sir to please address the gathering.
Please be seated. Once in a way, you have to get up to shake off your sleepiness. My good friend, Dr. Dinka Gitte, the principal of this great institution. Another friend, Dr. Jigimon, who has been very active in getting me down to Bombay, but of course kept me busy by taking me to all the law schools without giving me an opportunity to even do some shopping or even seeing the best part of Bombay. I'm about to take off to Sri Lanka. It takes about 1 hour to get there, right? Without even having seen the better part of, but I consider it my privilege and also a pleasurable experience to come to your institution and talk to these eager beavers who are seated here, all of them expectantly looking towards the future, the rosy future where you can make a lot of money, right? Unlike us, we who are judges, right? And so the topic for this afternoon is very, very appropriate, justice delivery in the Saarc countries. So now, India and Sri Lanka, definitely, we come within the Saarc countries. We have a lot of similarities, as I have been saying this a couple of times on my trips here. Sri Lanka is a common law country, as India is. We have that common law heritage derived from our rulers, English rulers who ruled us, and they gave you independence in 1947. When did Sri Lanka gain independence? Anybody? Any guess? 1948. The following year, we gained independence. And all the legislation that you have, they gave us. Macaulay's penal code is also our penal code, right? So whenever I decide cases on criminal law, if it comes up to the Supreme Court, I have to say this, I have a very famous research tool called SEC Online, which I subscribe, and I go and look up the cases. Because we have identical provisions. If you take the civil procedure, which you will learn without any kind of compunction, you must know this in the future, otherwise you can't represent your clients. That is also based on what they gave us, and so both countries boast of the same civil procedure, criminal procedure. The finest example is, the beautiful example is the Indian Evidence Act, which was transplanted in Sri Lanka. Of course, it has found its way to Singapore, Malaysia. I do not know about Pakistan, but all these countries under whose attraction the British government had a lot of things to do, have derived the same Indian Evidence Act. So now, therefore, I would submit that our laws are the same, then what about our justice? In jurisprudence, you will hear that there is a difference between law and justice. So today, the topic is justice delivery in Saarc countries, 8 countries. So now, law, where do you find the law? Where do you find justice? Now that Dr. Jigimon had started this, can I ask one of the students, where do you find the law? Where do you find the law? Law. Any idea? You can make a mistake. Very good. The majority of the law is in legislation. That's Fantastic. Right. When a judge delivers a judgment, a binding judgment in the Supreme Court, what is that? What is that? Is it law? Anybody? Anyone who can make a guess or make? It's an application of law to the facts that have been proved in the case. But when Kesavananda Bharati decided, right, in the guise of seeking to amend, seeking to make an amendment, you can't amend the basic structure. When they said that, and when that interpretation went right round the world, it has even ended up in Germany and Sri Lanka, we refer to it as far back as 1989 in a judgment. When that judgment was delivered, was it application of the law or interpretation or itself a new law? What is your argument? How would you look at it? That raises the question whether judges make law. There has been this controversy in jurisprudence whether judges interpret law or they make law. So I have always taken the view, subconsciously, impliedly, when we come out with these novel interpretations, we do it for the benefit of the people, right? We make law. There was a famous judge in the United States, Marshall. He said, you must know, Mr. Judge, you must know the boundary of your profession. Never stretch it. Never usurp the functions of the legislature. Keep yourself within your boundary. But having said that, he made a little bit of a contradiction. He said, we must also suitably interpret the law to changing times. Now, the Indian judiciary have caught on that second part. Not only the Indian judiciary, even the judiciaries in the Saarc countries, and they are now, we must, Marshall's all flows from that particular statement, and then they keep on interpreting the law to make law which is beneficial for the country. So therefore, I would tell you the word law, as this girl described, can be the law passed by Parliament, but even the interpretational part that we do can be the law in an extended sense. Not that we are trespassing on the provinces of the Parliament, but we are, by way of the interpretation, we make law. So if somebody tells you, or if you get a question in your jurisprudence paper, do judges make law? You boldly answer, yes, they make law, and give these examples. I must tell you, why do we do that? We do that in order to dispense justice. There's a gap between law and justice. When the parliamentarians enact law, sometimes they are never there. The law minister introduces, and then it goes through the houses, and then it finally gets the certificate to come. So law is passed. They say that it is Parliament passed it, but it is the policymakers who put that law into shape, and it is passed, and then thereafter, when it comes to us, we breathe life into it, and when we interpret it, it is the full sense of the law that takes shape. I will love to have Professor Venkata on the stage because I have a connection to him. I have a connection to him. I'm meeting him after 11 years. I'm meeting him after 11 years. These gentlemen, these two doctors are his old students, but I'm meeting him after almost 11 years. When I was Deputy Solicitor General in Sri Lanka, I must say this story to them because that's how they will not fall asleep. Right. So in the evening when I address, I narrate stories. So I will move a little bit, come back to justice later, and shift to Professor Raho, for whom I have a lot of respect. So I ended up at his university, not as a judge, but as a Deputy Solicitor General. I went there for a 2-week long seminar, or I will say residential workshop and study. My Attorney General had recommended me, and I ended up at his university. I lived in the hostel for 2 weeks. He used to have lunch with us, narrating a lot of stories. He will narrate a lot of stories now when he comes here. And he was a great academic. And then, at the end of the training seminar, we had a paper on international humanitarian law. So there were delegates from India, there were delegates from Afghanistan, there were delegates, all Saarc delegates. So there were 2 delegates from Sri Lanka, me and another lady, I don't know where she is now. She was in the foreign ministry. So the test was held on IHL. It was for about 1 hour. And they marked the paper, and they finally found yours truly coming first in that exam, in IHL at that time. Then he presided over the awards ceremony, and then he gave me 3 books, all awarded by the ICRC, and then he told me, that was in July 2014, they say, blessed is the giver. He was the blessed, but I was also, the recipient is also the blessed. I'll tell you why. He said, he looked at me and said, I hope with this achievement, you will scale the heights touched by one of our greatest academics, Professor M.K. Nawaz, right? He said that. I went back to Sri Lanka. Unfortunately, I couldn't enter the academia. I got a call and I was told to become a justice. So I was blessed by him, and 3 months later, I ended up in the Court of Appeal of the country. And since then, I have been looking around for him, and I have not been able to track him until his 2 students brought him here and put him in touch with me. So how beautiful this is. And we reminisced, and before he could speak on justice, let me develop that concept of justice, because it is the topic for today. And then I will, to shake off your sleepiness a little bit, I will narrate a story in Oliver Twist. I don't know how many of you have read classics. If you are going to improve your English language, they say, my father would always say, read Charles Dickens or Shakespeare away from the law. At least 1 book, read this. So I read Oliver Twist. There, he was working in a work house, or it was called, he was growing as an orphan. There was a lady, overpowering lady, who was the head of that institution, the orphanage. The husband was a hen-pecked husband. You know what it means. You know what it means? Never be a hen-pecked husband in the future, right? You are controlled by the wife. there were some thefts that took place in that workhouse. So the police came in. Now, Charles Dickens was a lawyer's clerk, I must tell you. He was working as a clerk for a lawyer. So he wanted to study law, but he started writing, and then so he became so famous. But when I went to London to do my master's, I used to meet all my Indian friends there, all my friends, I still have them. We used to go down Chancery Lane, go to see Charles Dickens's room from where he wrote his novels. He was a lawyer's clerk, so he knew what was happening in court. He knew the law. So then he was narrating this law story there. The policeman came to the workhouse and then caught hold of the husband, the cuckolded husband, if I may put it that way, right? And said, there are thefts. You were there in charge. And who is responsible for this? The husband looked at the police officer and said, he looked around to see whether the wife was around. The wife was not around. He said, it must be my wife who would have stolen these trinkets. It's your wife? Then the police officer told him, if a wife does something, she does so at the bidding of her husband. He said, are you serious? The police officer said, yes, that's the law of England. If a wife does something, she does so at the bidding of the husband. So this cuckolded husband was taken aback. But I don't know whether it is still the law, but I don't think the ladies will say that it is the law dictated by the husband, but then, now the law has changed, right? The law has changed now. If you do something, it is your act. I don't, but at that time in England, this was the, so he said, if that is the law is a bachelor, he said. Why? Because the bachelor, the law, has not married. Only if the bachelor, the law, marries, he will open his eyes, he said. I don't know what, right? Now, justice was in such a primitive stage. Charles Dickens was bringing it out. But today, it has advanced. And we interpret just to do justice. So the point that I am trying to tell you is, when you become judges, when you become lawyers, when you espouse the cause of your client, you must think out of the box. Don't go for literal interpretation of the provisions in a legislation, in a bare act. You go beyond that. An opportunity came to me after I came to the Supreme Court. If you Google, possibly this afternoon, Easter Sunday judgment, you will come across a beautiful judgment written by the Supreme Court of Sri Lanka. I think it was in 2023. In 2019, this gruesome murder, or like it happened in Taj Hotel here, a lot of churches were targeted. About 220 odd people died on the Easter Sunday day. Now, at that time we had a president, we had a cabinet and all that. Then the victims filed cases for violations of fundamental rights. Now, your fundamental rights chapter is virtually reflected in the Sri Lankan constitution. It's the same. All persons are equal before the law. Everybody is entitled to the protection of the law, right? So when the 1978 Constitution of Sri Lanka was drafted, we had English constitutions. As you know, English constitutionalists like Sir Ivor Jennings, they were averse to civil rights liberties. Now, if you look at England, it is quite late in the day when they brought out a separate legislation called Human Rights Act in 1998, way after our constitution embodied fundamental rights. So now these victims came to court and said, the ministers and the president have shirked their responsibility to protect us, and therefore the president must be held responsible for what had happened. The victims asked for compensation against the president, against the ministers. Now, I must tell you, I don't want to create controversies here. Sometimes we write our judgments as a joint judgment. We put our names one after the other, right? But even though we put our names one after the other in the judgment, and you will look at it as a joint judgment, it is really written by one person sometimes, or others. So this judgment, I was very junior when I got into the Supreme Court at that time. There were senior judges. They all looked at me. I'm making a very good confession here. I'm the one who wrote that judgment. So if you want to look at my style of writing, please Google that and have a look at that judgment. I wrote that judgment, but I was the fourth or fifth judge in that. For about 1 whole month, I was cooped in my room writing this judgment. Then I was thinking as to how the president can be brought to book. I certainly felt the president, as the defense, as the Minister of Defense, had failed the people by not taking remedial measures just before the attack took place. There was evidence. In fundamental rights cases, we don't take evidence, we take evidence by affidavits, as in India. So now, through affidavits, we found that he was lacking in his supervision of his police officers, police department, IGP. He was not meeting with the IGP. He was not. He was keeping a hands-off approach. My friends, my colleagues at that time, some of them have retired, they told me, I don't think you can bring the president under the aegis of the fundamental rights violation. You can't hold the president to have violated the fundamental rights. This was, I thought out of the box. But I must tell you, who helped me, it's all because of my academic training I got in the United States when I was a student. Now, I am developing the principle that you propounded, Dr. Jigimon. You said it all starts in law schools. It starts in law schools. The ideas that the faculty puts into our heads. Now, when I was studying there was a professor. When I was in the US, I was studying a subject called international contracts law. In the context of contract law, he said, contort. He said, contort. One day, he said, contort. He asked us, what is a contort? And I didn't know what a contort was. Then he said, breach of contract can become a tort. So when a breach of contract is also a tort, you can call it a contort. This is what he said. I carried this idea, and then I looked at the Constitution. The Constitution imposes duties on ministers, on the president. He had taken over the defense ministry. So I thought to myself, there's a constitutional duty on him to defend the nation by periodically summoning security meetings. So he failed. So I thought to myself, he had breached the Constitution. If somebody breaches duty of care, you say what? It is a tort. If somebody breaches the constitutional duty, you call it a constitutional tort. So we created constitutional tort, a contort, which was what I'm saying this is because see what a professor had put it into my head and how, as a judge, I developed it in that judgment. You can read it. If you Google that, you can see the development of contoured. But I must tell you this, as I was making my researches, I found India had also elaborated on this concept. I forget the case. I cited the Indian case. There was this Bangladeshi woman who had come to Delhi or Mumbai, and then she was sexually violated by some railway guards. It's a famous case. So there, the judges of the Supreme Court, rather High Court, judges of the High Court had invented this liability to be imposed on the state, on the president, on the defense ministry. But the assailants here, I must tell you, they all died. Churches, they died along with the bombing. They also died along with the other victims. We couldn't find them, but the victims were crying here before us. So we invented this constitutional tort, borrowed from India as well, and we did justice in the case. I hope law and justice, delivery, how it takes place in Saarc countries, you might now know there is a gap between law and justice, but judges have to narrow that gap, and it is teachers like you who should read around the subjects and then put it into the heads of the students here so that you will be suffused with this knowledge in the future to sort of charter the course of the future judiciaries and the legal fraternity in the future. So these are some of the thoughts that are coming into my head when I look at justice delivery system. We last Monday or Tuesday, or no, on Friday, Saturday, Sunday, we had this conference on AI. AI is swamping us. It is the message that I gave some of the participants at that conference. I would also tell the students here, you can use your AI tools to research, but don't use the very words that the AI tools are throwing at you. The machine learning, they are virtually throwing very good expressions, but never ever repeat it in your written briefings when you become lawyers. The lawyers are getting fined in the United States for making false citations. That's not justice. You are fighting for justice on behalf of your client. Rule of law does not dictate you to resort to quick justice. Justice delayed is justice denied. Undoubtedly it is so. But when you assist a judge, when you look up a legal provision and try and argue a case in the future, see that you argue it on first principles and you argue it on the case law that have been really laid down by the judges. Two lawyers in their written briefings gave judgments, false judgments or fictitious judgments never written by judges. That's what ChatGPT did to them. So those are dangers that lurk in your research. Please do your research on your legal databases. If you do your research on your common open AI databases, check on that even for your academic work. And recently, a professor is suing one of her students. Oh, no, it's the other way around. The student had been discussing some material with the professor. The professor had written that material in a judgment, in a case note or something, and then the student is suing in the US. So roles are being reversed as well. So you are at a great institution where you have a fantastic faculty. When you go out into the open, please remember, law is not justice. It is the interpretation you argue that will become justice in the future. So those are the thoughts that I have to leave with you. And there is also another aspect that you must bear in mind. Never ever stick to your own jurisprudence. Go across the passport control. Try and obtain masters like I did. Then the justice delivery will be fine. Now, your principal said, how did I manage to do 3 masters? My biggest regret is that I didn't do a PhD, right? I thought the 3 masters is sufficient, but even at this late stage, I feel like doing a PhD, but law is a jealous mistress, they say. Why? Because it will never allow anybody else to come between you and law. It leaves us with no time. Now I'm taking back a fantastic book written by this gentleman, a doyen, Fali Nariman, the father of that great judge for whom I have a lot of respect. Now, I love this gentleman a great deal. I'm taking this book, I'm thankful to you, but delivery of justice as I go tomorrow to sit in court will leave me with no time to skip this through. Maybe I will scan this through as I fly back to Sri Lanka tonight. I will read and finish this before the plane touches down. So I will carry away happy memories, have a great seminar, and wish you all the best in all your great endeavors that will make you a complete lawyer in the future. Thank you very much.
We are sincerely grateful to your invaluable insights, sir. Your inspiring address has given us much to reflect on and learn from. I now call upon Assistant Professor Ranjana to introduce our esteemed guest of honor, Professor Dr. R. Venkata Rao, Vice Chancellor, India International University of Legal Education and Research, Goa.
Thank you, ma'am. A very warm welcome to all those present here. It is indeed my privilege to introduce Professor Dr. R. Venkata Rao to this august gathering. Sir has previously served as the Vice Chancellor of NLSIU Bangalore. He had joined NLSIU Bangalore as Vice Chancellor on 11th May 2009. After completion of his first term on 10th May 2014, his appointment as Vice Chancellor has been renewed for another 5 years from 2014. After serving for 10 years, 2 months, and 21 days as the Vice Chancellor, Sir has laid down the office of Vice Chancellor of NLSIU Bangalore on 1st August 2019. Thereafter, he has assumed the office of Chairperson, Vivekanand School of Law and Legal Studies, and Vivekanand School of English Studies under the Vivekanand Institute of Professional Studies, New Delhi, on 16 September 2019. Professor Rao's academic qualifications are BA Honours Literature, MA Literature, ML, and PhD and LLD Honoris Causa 2017 from Utkal University. He was awarded Professor N.R. Madhava Menon Best Law Teacher Award for the year 2018. Professor R. Venkata Rao has been awarded the Attorney General K. Parasaran Award in recognition of his outstanding scholarship in legal education by Capital Foundation Society, New Delhi on 1st September 2019. To date, he has 45 years of teaching and research experience. He has a distinction of serving the statutory bodies of almost all the law schools in the country. Besides, he is a member of the Board of Governors of Indian Institute of Corporate Affairs, New Delhi. He has also served as member, Governing Council, Indian Law Institute, New Delhi, and member of the Academic Committee, Indian Institute of Public Administration, New Delhi. He has served as an independent director in prestigious PSUs like Bharat Electronics Limited, BEL, Bangalore, Hindustan Aeronautics Limited, HAL, Bangalore, Goa Shipyard Limited, Goa. He is also a member of different committees in the Bar Council of India and is associated with the prestigious bodies like UPSC, State Service Commissions, UGC, and NAC, among others. He has the distinction of receiving gold medal for the best PhD thesis from Andhra University in 1993, the best researcher award from Andhra University in 2003, the best teacher award from Government of Andhra Pradesh in 2006, and he has been awarded the best Vice Chancellor Award for outstanding contribution to education during the World Chancellors and Vice Chancellors Congress in 2014, held on 27 June 2014 at Mumbai, Amity University, Noida, which also awarded Amity Academic Excellence Award twice, once in 2017 for the most distinguished contribution towards propagation of doctrine of knowledge at the 17th International Business Summit and Research Conference in Bush era, and again in 2019. He has been awarded Professor N.R. Madhava Menon Best Law Teacher Award for 2018 under the aegis of Society of Indian Law Firms and Menon Institute of Legal Advocacy Training for outstanding services to the promotion of quality legal education. Professor R. Venkata Rao has been awarded the Attorney General K. Parasaran Award in recognition of his outstanding scholarship in legal education by Capital Foundation Society, New Delhi on 1st September 2019. He has authored 6 books and published more than 130 papers. He has successfully guided 3 LLDs and 21 PhDs. He has visited more than 30 countries for his academic and research activities. He was the chairman of the Board of Governors of Asia Law Institute, ASLI, for the year 2010 and 2011. I now invite Sir to address the gathering.
So you have settled down? I'd like to start on a lighter note because proceedings have been too serious, perhaps. Especially from 2:15 in the afternoon to 3:30, when your body constitution asks you to do something else. It's not fair on our part to speak about the constitution of this country. Okay. Now, when you were standing, I was reminded of the judicious responsibility of a teacher. A teacher is one who makes his students outstanding and not standing. I want each one of you to be outstanding. Please remember that, okay? And the second one is, when Honorable Justice was speaking about constitutional thoughts, I was immediately reminded of the synergy between and among the Saarc nations. You know, Article 300 of the Constitution of India speaks about constitutional thoughts. Read Article 300 of the Constitution of India. The government of India may be sued, but the beauty of that is, most of the Saarc countries, first generation judges, were trained in Anglo-Saxon jurisprudence from 1950 to 1980. The ghost of common law was haunting them. The Eurocentric approach was haunting them. Therefore, we were all taught the 19th century doctrine that the king can do no wrong. You must have studied it. The king is the fountain of justice, which translated into the words of law will say absolute state sovereignty. But today, absolute state sovereignty has become humanized state sovereignty. Humanized state sovereignty. The king can do no wrong has come to mean the king shall do no wrong. If the king does wrong, the king becomes a commoner. Be you ever so high, law is above you. Number of Saarc countries have been following this doctrine. And that's what unifies this wonderful subcontinent. Why this program is very important is, I'm reminded of Alvin Toffler's book, Power Shift. He wrote in 2008. He asked a simple question. 19th century was ruled by Great Britain, United Kingdom. People said the sun did not set in the British Empire. Of course, Alvin Toffler says the sun was afraid it would also be colonized. Therefore, it did not set in the British Empire. Therefore, it was keeping itself awake. So, from 19th century, Great Britain, power shifted after the Pearl Harbor attack to the United States, whose accidental entry into the Second World War made it a hegemonistic country up to 21st century. So Toffler asks, if 19th century was ruled by Great Britain and 20th century was ruled by United States, to whom will power shift in 21st century? Beautifully answers in the first chapter, power will definitely shift from United States. He does not answer to whom it will shift. Then he says, will it shift to Europe? Because Europe was emerging very powerful. See, in 2009, he made a prediction that it will never shift to Europe because Britain will not allow Germany to become powerful again through Europe. And Britain will exit from Europe. That's what happened in 2018. That's what you mean by a researcher. In 2009, he could predict that Europe would become weakened by Britain's exit. Then he asked the question, will the power shift to Gulf countries? Because Middle East, they had oil. Then he says, no. In the history of mankind, 3 M's have ruled. First is muscle power, law of the jungle. Whoever has muscle power, the lion ruled, the lamb had no place. Muscle power gave to money power. Whoever had money. To such an extent, we used to say in the classroom, perhaps to a certain extent it is true today also, the golden rule of law is that he who has gold always makes the law. The golden rule of law is that who has gold always makes the law. So power shifted from 1 M muscle to 2nd M money. And then he says, in 21st century, it will move to 3rd M called mind power, to knowledge societies. And there will be ultimate distinction between knowledge haves and knowledge have-nots, apart from male and female. All distinctions will disappear. And this knowledge society you will find in Asia and particularly South Asia. So by around 2050, South Asia will become powerful. In that context, Saarc assumes large importance, remember. However small might be a nation, however big might be a nation, remember, it is, please remember, geniuses are never created in isolation. Geniuses are created through synergy and through symbiosis. And only when we have that synergy and symbiosis, this South Asia will become powerful. And in that context, this international symposium on legal systems in Saarc assumes great importance. I'll make just 2 personal references to the contribution of National Law School of India, University, Bangalore, to the emergence of legal power banks in South Asia. Most of you may not be knowing that there were 5 seats reserved in Bangalore National Law School for foreign nationals. And each year we used to receive applications more than 200 in number. Most of them from United States, United Kingdom. But right from day one, thanks to the commitment of Professor Madhav Menon and the powers that be, these 5 foreign national seats were reserved only for Saarc countries. Not even one from United States got it, in spite of the paying capacity. Because we said, it is not the dollar which is important to us, but it is the inherent symbiosis and the strength. And at that time, Bhutan never had a law college. Bhutan never had a law college. And the first generation of judges from Bhutan, all are from National Law School. To such an extent, my students say, sir, for another 20 years, all the chief justices of Bhutan will be National Law School alumni. We had students from Sri Lanka. Invariably, students from Sri Lanka happen to be girls, by and large, 99%. And most of them are good academicians and judges now. Yesterday, the judge of Supreme Court of Nepal, Sapna Malla, was here. Her son was our student. Then there were students from Mongolia who have now become members of parliament. Now that is how the solidarity of legal bank in Saarc developed. Not only it did not stop there. Advocate K.K. Venugopal, Professor Madhav Menon, and next generation Shivakumar, Venkatramani, and others came together to start an institution called Saarc Law. And South Asian University was the result of that. If in Delhi today you have South Asian University, where students from Saarc countries participate, remember, it is because of the initiative that was taken. That means the small steps that were taken are bearing fruits today. And today's step also could be a small step, but like what Neil Armstrong said, it will be a giant leap for the mankind as far as Saarc is concerned. He was speaking about, your principal wanted me to speak about delivery system of justice. I would ask you only one question. Mahatma Gandhi wonderfully said, everyone says, let there be peace in the world, but no one says, let peace begin with me. If peace does not begin with you, how can there be peace? And Gandhiji in that paragraph says, everyone wants to go to heaven, but nobody is prepared to die. Without dying, how can you go to heaven? So, everyone wants peace, but nobody says, let it begin with me. Gandhi used to quote, and Martin Luther King used to refer to it, if you seek peace, cultivate justice. If you seek peace, cultivate justice. Injustice anywhere is a threat to justice everywhere. When we come with the criticism that there have been thousands and thousands of crores of cases pending in the courts in almost all the countries, have you ever asked a question for yourself, to what extent are we contributing? If everyone cultivates justice, will there be any requirement for us to go to a court of law? If you seek peace, you must cultivate justice. If everyone cultivates justice, will there be any requirement? Ask for yourself the question before you speak about the collapse of the legal system. Why I have asked you is, the beautiful book that was presented by your principal, Fali Nariman, has also written a book, India's Legal System. Can it be saved? The next line is that. The title of the book is, India's Legal System. Can it be saved? My humble request to the principal is, keep 5 copies of it. And make students read it, and make it followed by a book discussion of that particular theme. After 1 month, both faculty and students. Can India's legal system be saved? Why I'm saying this is, unfortunately, the Saarc nations which represent one of the most ancient civilizations in the world. I'm not naming any one of the countries, all the countries. And which had excellent systems of indigenous systems of administration of justice. Remember, we were brainwashed in a sophisticated way, and our indigenous systems were replaced by Euro schools of thought. And today, if you have administration of justice in the courts of law, most of it represents the colonial hangover. Slowly, we are coming out of that. But do you know, in the hinterland of the tribals, the indigenous system practiced by them is centuries ahead of the judicial systems of us. When you are today speaking about mediation, arbitration, conciliation, and you are calling them not alternate disputes but appropriate dispute resolution mechanism, perhaps the only dispute resolution mechanism, do you have an idea that our tribal system used to focus on dispute avoidance and not dispute resolution? Today in the United Kingdom and United States, in law schools, they are teaching a subject called dispute avoidance, risk management. Nothing new about it, but it was covered by the locals. So when you would like to reignite the justice delivery system in the Saarc countries, don't superficially go to the top. Go to the healthy practices that were prevalent among the fishermen's community in Sri Lanka. MUMBAI. Sri Lanka is a wonderful coastline. Okay. Then arbitration. Then social safety networks in the indigenous systems. Study them. You may not have immediate solution. There will be layers of resistance. Now, especially when you would like to bring about a transformation, the layers of resistance would be very tough. But you have to gradually overcome the layers of resistance. That would happen when you take the first step. Because as somebody said, if you want to reach the top of the mountain, never look at the top. Take the first step. The altitude to be covered remains n-1. Don't look at the top again. Take the second step. The altitude to be covered remains n-2. One fine morning, like Bachendri Pal, you are on the top of Mount Everest. Let this seminar be the first step. Let in the assignments and the projects that the teachers would be allotting, don't give run-of-the-mill topics. Okay. Right. Give topics with a vision, with a sight. Okay. As to how indigenous systems, delivery system, okay. Nyaya Panchayats, what do you mean by that? Mumbai. Go through ancient pages, because especially maritime disputes that were settled by Sri Lanka, because I come from Orissa, number of business people from Orissa went to Sri Lanka and settled down. Orissa has supplied maximum number of, much before Tamilians went there. And they used to tell us about the settlement of disputes. I'm only giving you a single example. Okay, go to other Saarc nations, you will find disputes. Okay. Matters relating to family law, how you settle them. But why do you magnify them and follow the European schools of jurisprudence? Not that they are bad, but they are not the only ones. Please remember that. Okay. And in the introductory remarks, they said, I have 45 years of experience. Immediately, I was reminded of Bernard Shaw's definition. Good judgment comes out of experience, but experience comes out of bad judgment. So I had 45 years of experience of bad judgment. So we had 45. India had become a republic in 1950, 75 years of experience. Now we have arrived at a stage where you can separate the chaff from the grain. Pick it up. Come with durable solutions. But ultimately the objective should be to make surroundings around you more safe, more secure, and more just, whatever you may call it. More safe, more secure, and more justice. And that's what you mean by ultimate justice delivery system. Justice delivery system does not mean Article 32 and 226. For God's sake, remove that from your brains. Remember, justice at the grassroots level. Remember, what is that you are doing? And you will have wonderful examples from Saarc countries. Because why I'm telling is, in the last 2 years, many disturbing things have been happening all over the world, that the world order has become a world disorder. Global order has become a global disorder. What are those things? Just have a look at it. Inward-looking attitudes. Everyone started looking for his own self. Then excessive protectionism. Everyone wants to protect his own nations. Then disbanding the multilateral orders and criticizing the United Nations. Somebody said the United Nations is like God. If there was no God, there would have been need to invent God. If there were no United Nations, there would have been need to invent. Look at the good work that is done. And United Nations itself says powerful, strong, regional organizations are essential. Because it is either coexistence or no existence. Please remember that. And young ones, you are the foot soldiers of that. I'm a cricket buff. My lord is also a cricket buff. I have started my second innings in a 5-day test match. You are yet to face the first ball in the unlimited IPL league. And you will be there to see what is happening. And therefore, use these legal systems, okay? Take essence from the other legal systems. No country is big, no country is small. Let's have enlightened self-interest and let us extract the best. The rest I will answer during the question and answer session. Thank you very much. God bless you. Thank you.
Thank you, sir, for sharing your wisdom and perspectives with us. It is always an absolute pleasure to listen and learn from you. We would like to open the floor for any questions from the audience. If you have any queries or would like to seek any further insights from our esteemed speakers, please feel free to ask. I request the faculties to kindly monitor the question-answer session. Students, you may please raise your hand and ask the question to the speakers.
Sure, sir. Am I audible? Hello, sir. My name is Pranav Patade. I'm a second-year law student. My question revolves around the specific parameters that are essential for a true success of a justice delivery system. So I'll come to the point why I'm asking this question. My question is specifically to Honorable Justice Navas, sir. So here in India, the appointment of judges is done through collegium system. And in Sri Lanka, you have Constitutional Council, which is similar to what we had introduced, which is National Judicial Appointment Commission. The features are similar to what you have in Constitutional Council for appointment of judges. So I just want to know your experience with respect to the Constitutional Council, how effective it has been with respect to appointment of justice, because it is one of the essential features that adds value, or it encourages the citizens of a country to build a trust in particular judicial system. So if you can share your opinion with respect to the pros and cons of that particular system, I would be happy. Thanks.
May I know it?
My name is Pranav Patade. I'm a second-year law student.
Second-year law.
Yes. I'm from the same college and from the state itself.
You're not from Sri Lanka.
No, sir. So before this event, I studied a little bit about Sri Lankan, specifically how similar is the specific judicial system with respect to Sri Lanka. I found that similarity, and we had similar struggles around that.
It's a very sensitive topic. You have, when you posed this question, I was wondering whether you knew some of the concerns concerning the Constitutional Council in Sri Lanka.
I don't know much of a detail, but what I've heard was there had been some executive interference with respect to Constitutional Council. There had been an amendment wherein...
Yeah, it's like this. As you rightly said, there is a collegium here, and the collegium, of course, recommends judges, or rather it appoints judges, right? And it goes to the president and of the country, and then president has to appoint whoever collegium recommends. But it is the other way around in Sri Lanka. It is the president who nominates the judge, and then Constitutional Council can approve that nomination or disapprove that nomination. So now that happened quite recently in the case of the president of the Court of Appeal about 3-4 months ago. You know Mr. Ranil Wickramasinghe, the president, the president who has just left office as a new president. So he recommended the then president of the Court of Appeal to the Supreme Court. Court of Appeal is just below the Supreme Court. He recommended his name. That name went to the Constitutional Council. The Constitutional Council shut it down. The Constitutional Council said, no, we will not approve this appointment. We will not approve this appointment. It gave reasons, right? If you can Google, you will find the reasons. Constitutional Council gives reasons. So that, it was certainly if you are denied promotion to the Supreme Court, if you have come to the Court of Appeal, if you have become the President of the Court of Appeal, your next step is coming to the Supreme Court. President sends your name, but the Constitutional Council says no. You then naturally that judge will feel a little concerned. He will be affected. So somebody came to the Court of Appeal, Supreme Court, alleging violation of fundamental rights against the Constitutional Council. So now that case, I didn't hear that case. That case was thrown out. In other words, one of the petitioners came to court and said, by refusing to approve the nomination made by the President, the Constitutional Council had violated the fundamental rights of this judge. That was the argument. But the Supreme Court rejected it. So that particular judge could not become a Supreme Court judge. He still functions as the President of the Court of Appeal, and people below him have now come to the Supreme Court. So I don't know. I have to be very restrained from certain statements if I were to answer that question in public. You can ask me in private.
Sure, sir.
Right?
Sure.
You can ask me in private because you are a law student and comparative knowledge of what is taking place in a neighboring country is something you will be very keen to find out. You will not find it in the Google. You will not find it in the ChatGPT, right? You will not find it in Perplexity. You are perplexed, I can see. Please ask me outside this. I will answer that question.
Sure, sir. Thank you, sir.
Thank you.
A very interesting point you must understand is, Today there is a growing demand in India that the route to Supreme Court should not be direct. There must be separate Court of Appeal. There must be separate constitutional courts. Here you can take a leaf out of Sri Lankan experience. In Sri Lanka, you have a Court of Appeal separately. Now, one solution to the decongestion of docket explosion in the Supreme Court is to have separate courts of appeal and separate courts of to deal with constitutional matters. You know, United States Supreme Court, how many matters it deals with per year? Just in hundreds. And Indian Supreme Court admits more than 5,000 cases a day. I'm not exaggerating, it's a fact. Okay. Therefore, these experiences from the fellow Saarc countries we have to learn, and how the Court of Appeal is working there, okay? How they are able to weed out. That makes our system strong, okay?
Thank you, sir.
I think the judges in India, they didn't want to give the power of appointment to anybody. And you know the judges on advocates' case and all that, all those cases, you must study those cases. Those cases, when I study them, those are good cases where the judges say that appointment must be with us, right? So, but I was speaking to the Nepalese sister who is with us, who was with us, and she said she has to go before a parliamentary hearing, like in the United States. So, the United States, you get appointed on party lines sometimes. So there are variations in Saarc countries, but if you want to know more, you can meet me outside.
Sure, sir. Thanks.
More questions, please. We'd like to interact with you.
Hello. Good evening, panelists. Sir, I would like, good afternoon first of all. My name is Shobhit, I am from the 8th semester right now. So my question right now is, as Professor Dr. Jigimon rightly pointed out, the increase in pendency of the cases. So my question over here is, with the rise of more and more linguistic challenges which we are seeing right now, especially in the southern states and many other states as well, so is All India Judiciary Examinations, will it be always going to be a dream for the law students only, or is it going to do something good for us, or how is it going to be? Is it ever going to come? And sir, one more thing, sir, if it comes also, will it be going to do something regarding the pendency of the cases or not?
The question with regard to the pendency of cases is just because, as sir was also pointing out, we have to look out for the how to clear the vacancies that are there in the judiciary, first of all. That is one of a big challenge that we have in our court system. As I said, the number is not matching the number of courts that we have. And second part with regard to the All India Judicial Examination, see, we have the civil service examination. The country person who is coming to the post of a civil servant in any state is concerned, it is not never matching actually. Orissa person is always there in Kerala, a Kerala person is there in Kashmir, or some other states are concerned. So if that can be resolved, why not a system of all India judicial examination? Because that learning of the language is a part that we all learn if we have been given no choice to, right? Many of you might have been from the other states are concerned, but you might be learning Marathi over here. So that is the same example that you can take in for the purpose of the language barrier is concerned, because it is all it's up to us to decide how do we handle. When you said about All India Judicial Examination, one I would like to mention here is that during the Justice Deepak Mishra's period, there was a thought of having a select from, like the NDA format of a judicial, wherein students are being taken up from the 10+2, and then they can be trained up into judicial officers by giving them an LLB education in a judicial academy format, in the National Judicial Academy format. And a syllabus, a course, everything was developed in then, but couldn't be implemented. But a state plus forward was that Nagpur NLU adopted that scheme, and they are running specific LLB program only for the judicial purposes. So these kinds of things would definitely come in future, wherein you said language barrier is just something which is learnable. And I don't think anything is a barrier when it comes to reaching out for the judicial purposes.
I would add to. You must have heard the word cooperative federalism. For a long time I thought cooperative federalism means states should cooperate with the center. But recently I read an article. Did anyone think about states cooperating with states in cooperative federalism? States themselves start fighting with states, not with center. River water disputes, courts, and is it cooperative federalism? And therefore, before states talk about cooperative federalism with the center, first let them cooperate between themselves and among themselves. The biggest block to all India judicial service is the mind block. And an apprehension that you would be subsumed by the union, okay? And therefore, those mind blocks are removed. And you have to carry on the torch to remove those mind blocks. Our generation has failed, let me tell you very clearly. And parochial loyalties, okay, you have to take that to make all India judicial service a reality. Okay?
Thank you so much, sir.
Anybody else?
Good afternoon all. My question is to Justice Navas, sir. So my question is that...
Come here. This Boston is obstructing.
So my question is that how the judiciaries in the Saarc countries can facilitate in the justice delivery. And for the matter of that, justice delivery, I doesn't mean just the legal justice system, but the social, economic and political justice that is enshrined in the Constitution of India.
I said before, there's a lot of synergy, there's a lot of propinquity, there's a lot of affinity between our judiciaries, particularly when we follow common law traditions. So there is social justice that has to be achieved, there is economic justice that has to be achieved. There are many facets of justice that could be achieved by using the available resources at our disposal. Well, just like we do a comparative jurisprudence process, we should share the wisdom of each other's judiciary. What India does, Sri Lanka must be able to have a look at it. Right? Because I am a subscriber to SEC Online, Manupatra, and even some time ago LexisNexis, I know what Indian judiciary is deciding. I read about it in live law, I read about it in bar and bench, right? Yeah, and it comes to my phone, and then I know what has been going on, and then what I do is I immediately go and download it, official versions. So there has to be that facility given to some of the other judiciaries as well. Now last night somebody met me and said, "Sir, I have all your judgments now." And then he showed, he had downloaded, right? So this kind of passport control, beyond the passport control, the infusion of each other's principles across the border, we have to promote it. That is what the future Chief Justice of India, Justice Suryakant, mooted it, and I endorsed it at the conference. He said he wants to do that. Right? He wants to do that, and so I think we are in go for some good times in the future. Even Honorable Justice Gavai, who will be taking over in May, said the same thing. This interaction, it has now become very, very active, thanks to the academia as well. There was a time when judges, I don't know whether they were ever present on occasions such as this. Now we get to come. Thanks to CLEA, thanks to Professor Rahu, who opened his space to various nationalities at his university. And now what happens is a lot of journals are coming out discussing this, and the academia, as law students, you all also must start engaging with domestic jurisprudence and see how it has been transplanted in other regions. Why I spoke about Indians Evidence Act was, it is the same. So how do the judiciaries interpret similar provisions? So we will achieve this economic justice and social justice in a beautiful way if there is engagement among ourselves in the future. Okay.
Thank you, Lordship.
Any others? More questions, more the merrier. Yes, yes.
Yeah, it's the last. Yeah, it's the last.
Greetings of the day, sir. Myself Sakshi Patil, final year student. I have a question regarding respected to Navas, sir. While the speech you gave, delivered the speech, you said there should be, we should narrow down the concept between the law and justice. So what is your point to do such things? Like, you have a long experience in judiciary. So there are various students who are going to appear for judiciary this attempt. So I need to ask you that what are your pointers to narrow down that gap between law and justice?
There is certainly a gap between the law and justice, right? Certainly a law.
Yeah.
Law is the written law that you are studying now, where? In the textbooks, in the Bare Act which you are possessing. That is the written law, the law. But when you appear for a client, or when you appear for an exam to become a judge, you may have to do more than that, more than, right? Justice, now somebody said economic justice, how do you deal? Now when I decided that Easter Sunday judgment, victims came before us, right? Children had died, a woman came, a lawyer who was eating breakfast on that particular gruesome day, he came before us. And he said, look at the injuries that I had suffered. So now, he had undergone operation at his own cost. So we have to use the fundamental rights jurisdiction to give him what? Economic justice, to remedy what he had done. So when we do that, now if you look at the chapter on fundamental rights, it does not say, for these injuries, you must compute this and then give him so much. It doesn't say that. It doesn't say that. So law does not give you notions of justice, right? So judges, when there is a strict formalism in the law, you mitigate it and bring home the law to the victim. It's only the victim who comes. The aggrieved person comes before us. So when you narrow it, when I said narrowing the gap, by making a decision, we make the law more beneficial to the mankind. The law will not say that, but the judges must say that. You don't have to worry about it now, because you are a student, but know that what you have got to do in the future. When you argue a case, you argue just to bring justice to your client who wants, now as a disabled person, Now, disability right, how do you, recently I read something, he was denied the right of passage to a foreign country to compete. So court said, no, he must be allowed to go. His disability can't be an impediment. So this is how we do justice. So there is a difference, but you can narrow it down, the difference between law and justice. Do you understand that? Right, I hope.
Just try that one sentence. Your question has prompted me to go back to Justice Oliver Holmes. Oliver Holmes had a similar interactive session with college-going students in America. And all of them said, we are going to practice in the courts. And immediately said, young man, please remember, from tomorrow onwards, you will be going to a court of law and not court of justice. This is the word he has used. You will be going to a court of law and not a court of justice. That exactly is your question. Why did he say that? Then he said, in court, don't expect absolute justice. Justice is administered according to accepted principles of evidence and law. And you may come across few judges who refuse to go beyond the dictionary meaning of the word. They just look at the dictionary, they translate it and they give. But don't lose hope. There are judges who move from text to context. And because the business of a court is to dispense justice and not to dispense with justice. He said.
Yeah. So he was a little, I know of this history. He was a little formalistic when he said this. He said, when you come to courts, let me interpret the law in its strict terms. I think he said that when there was a famous judge, I forget his name. He was a good friend of his. He never ended up on the Supreme Court. He was a district judge of Washington, D.C., and he was in touch with this Supreme Court Justice, Oliver Wendell Holmes, as professor says. Right? So he asked him, how do you deal with justice? He said, courts are not citadels of justice, as he said. Courts are only there to deal with the law. So some judges like me, right, there are judges who are literalists, textualists, look at the law and then interpret, right?
And you know, my lord, he gave the example of a great international court judge, okay, McNair. He was asked to interpret a will. In 2 minutes, I'll explain to you. There was a happy family, a young man, wife, they had 2 kids, and the young man had his mother also. Happy family, no differences between mother-in-law and daughter-in-law, okay. Unfortunately, the young man was suffering from a terminal disease, pancreatic cancer. He executes a will, and he dies. The will is opened after death. All my property should go to mother. This is one sentence he wrote it. All my property should go to mother. Mother was very old. Then the wife was surprised. It was a happy family. How could he make me and my children destitute? And his mother said, no, I'll take care of you. No, fine, you will take care of us, but there's something wrong. The matter went to a court of law. The court also found that there is something amiss, but mother means mother only. But the judge, he went into the habits of that young man, and he found that young fellow has a quixotic habit of calling his wife mother. He had the quixotic habit of calling his wife mother, mother of children. Therefore, what he meant was the property should go to his wife. Then he interpreted, the will should be interpreted like that.
So that's a very good answer.
Okay, thank you.
I will expand on that a little bit before we go, we wind up. Now, There was a will, a famous case you will come across in your jurisprudence lectures. A grandfather had willed it for the grandson. He said all the properties to the grandson. Right. What happened? The grandson knew that the grandfather had written all the property for him. You know what this grandson did? He killed the grandfather. All right? He killed the grandfather and he claimed under the will. Clever judges said, testator willed it for you, but you are killed. Because of your wrong, because of your crime, you can't benefit under the will, even though the will said what? Will said that it must go to him. So this was the judgment in that case. So judges have to do this. Then, right, that is the whole purpose of justice. Delivery of justice means just that, right? Injustice to him, no, it's not injustice to him, it is justice to him. Justice to whom? Justice to the guy who killed the grandfather. That is justice. Do you get it? So you have to become great judges and lawyers to argue like this in the future, right? I hope that we have sparked your interest in this. Thank you.
Thank you to all the panelists for your insightful responses to the questions of the students. We are deeply grateful to your thoughtful contributions to the discussion. To formally conclude this enlightening session, I now invite our esteemed principal, Professor Dr. Dinkar Gitte sir, to deliver the vote of thanks.
Honorable Justice AHMD Navas sir, Judge Supreme Court of Sri Lanka, Professor Dr. Venkata Rao sir, Vice Chancellor IIU LER, my friend Jigimon sir, Dr. Jigimon sir, who is a Dean of Amity Law School, all the students, all the faculty members. I would like to thank AHMD Navas sir, Justice AHMD Navas sir, for gracing this occasion and giving an insight about justice delivery system in Saarc countries, whereby he has opened a nuances and a curiosity among students to learn about justice. Can there be a perfect justice? Law is different than justice. So, sir, definitely, student would be doing a lot of research. Now, you may be leaving this topic here, but I'll tell you, our students will carry it forward. Thank you so much, sir. Thank you so much for your session. Now, my guru, Dr. Venkata Rao sir, Vice Chancellor. When I was in National Law School, 2009 to 11, and one more year for research, all 3 years, I was under sir's guidance. I have a lot of stories, though we don't have that much time, with interaction and how he has groomed me to be what I am today. When there was a doubt among many other faculty members, a cloud of doubt you can say, he always believed and he used to say, look for this boy, he may be naughty now, he may be mischievous now, but he will definitely become something one day. Sir, thank you so much for belief when others, that's his vision, I'll tell you. And the one-liners which he uses in his speech, not only that, but if you have listened to him carefully today, he has opened up the jurisprudence about justice, questioning whether can there be an actual justice or justice is just perceived. That's what the great people, great scholars do to their students. Look at Sir and his age, so enthusiastic to share the knowledge to the students, and he would do it till his last breath. I'm sure of that. Thank you so much, sir. A great personality. I simply called him And sir, I said, we have a seminar. Would you please attend the seminar? And he said, Dinkar, I am there. Don't worry. Sir, thank you so much, sir. Because he always wants to be among students. And when we were sitting, jokingly, HMD Navas sir, Justice HMD Navas sir, asked him, sir, for last 10, 15 years, I am seeing you like this only. What is the secret you have maintained? And he said that I am younger because I am in company of young people. And that is students. Sir, thank you so much for gracing the occasion. My friend, Jigimon sir, I keep on meeting him once or twice in a month. A very good friend of mine. And I must say you, I mean, I know sir since last 10 to 15 years because he was my senior in NLS Bangalore. And from there his association with seminars and others. I must thank on behalf of KLE Society's KLE College of Law. Justice AHMD Nawaz sir is here because of all his efforts. Please give him a big round of applause. Thank you so much, sir. Now, why they are clapping, you know, sir? They want you to bring more justices now. You have to do that for KLE College of Law. Thank you so much, sir. Thank you one and all for having a patience for 2 hours. Justice, and lastly, I would like to quote my teacher, Vice Chancellor Venkata sir. He says, questions are more important than answers. So definitely, this symposium must have raised so many questions among you. While both of them were giving their speeches and something was going in my mind, and I was thinking about justice, justice in nature, and justice, and all of a sudden thought process came to my mind, and it was that, I mean, how do you perceive justice? A frog eating insect, then a snake eating frog, an eagle eating snake, though it's a type of a food chain, but what about justice to that insect, to that frog? And with respect to the same thing, with respect to human beings, when a crime is committed, the punishment may be 15 years, 20 years, life imprisonment. But the irreparable damage which has happened to that family, the person will not come back. So can we call it a justice? It's a larger question which I am putting to the audience, so we will think on it and then deliberate it again in the classes. Thank you so much. Thank you so much.
Now, some of you might have heard there is a word called restorative justice. Restorative justice. If you have not heard of it, please note it down and look at it. And then frog eating fish, read Matsya Nyaya in Nyaya Samhita. There is a word called Matsya Nyaya, the big fish eating small fish, whether it is justice or not. So this is how you must open your minds. God bless you. Thank you.
Sheikh Shazia, Milind Gurchal, Milind Gurchal. Okay. Yogesh Bhosle, Asfa Isa Sheikh, Asfa Isha Sheikh, Shazia. Deep Rasgotra, Deep Rasgotra, Chetna Hemant Bhagat, Sapkal Tushar, Milind sir, Sapkal Tushar Gulab Rao, Nikita Kori, Sunita Patil, Sunita Patil, Santosh Popatrao Hande, Manali Mokal, Archana Gavai, Archana Gavai, Swapnalata Kulkarni, Shraddha Kulkarni, Shantaram Bedekar, Gangalapadu Lepak Shapa, Zunjrao Ganpat, Shashikant Chandan Shive, Shashikant Chandan Shive. I request all the students to be seated. Dikshit, Shobit, Divya Prakash, please be seated. I will be calling out the year and only that year will come to Pooja ma'am here. Nobody else will proceed here. 5th BLS LLB, please get up. 5th BLS LLB, please get up. 5th year, Jay, you aren't. 5th BLS LLB, quickly. Followed by 4th BLS LLB. Only 4th BLS LLB, 3rd year please be seated. 3rd year please be seated. 5th BLS LLB and 4th BLS LLB, please form one line. If I see you crowding Pooja ma'am, I will stop the attendance. Kindly form a line. This shall be followed by 3rd BLS